House will come back to order. Members will please take your seats. Members, please take seats. We need to clear the center aisle, please. Please, members in the center aisle. Members will please come into the chamber. Members will please come to the chamber, take your seats. Members that are standing in the center aisle, that's this aisle right in front of me. That's the one in the center. That one. No one here likes to be in the center. They like to be on the, I won't go there. So members will clear the center aisle. Mr. Doorkeeper.
Mr. Speaker, the President Pro Tem, and the members of the Senate await entrance to the House chambers.
Allow the President Pro Tem, and the members of the Senate to enter the House chamber, and will the messenger please escort them to their designated seats. Thank you.
Members of the General Assembly, this joint session will come to order. All members, please take your seat. Mr. Sergeant at Arms.
Mr. President, the Honorable Michael P. Boggs, Chief Justice of the Supreme Court of Georgia, the Justices of the Supreme Court of Georgia, the Honorable Amanda H. Mercier, Chief Judge of the Court of Appeals, and the judges of the Court of Appeals await entrance to this chamber.
Mr. Sergeant at Arms, please allow the Honorable Michael P. Boggs, Chief Justice of the Supreme Court, the Justices of the Supreme Court, the Honorable Amanda Mercier, Chief Judge of the Court of Appeals, and the judges of the Court of Appeals entrance to this chamber. The House doorkeeper will escort them to their seats. All members, please take your seats. The clerk will read a resolution.
House Resolution 805 by Representative Bestration to the 104th. A resolution calling a joint session of the House of Representatives and of the Senate for the purposes of hearing a message from the Chief Justice of the Supreme Court, inviting each other justices of the Supreme Court and each judge of the Court of Appeals to be present at the joint session.
I would like to take this time to recognize some very special people here today before we get started. It's always a pleasure to be in this house, and it's always a pleasure to be beside the Speaker of this house, Mr. John Burns. Can't mention the Speaker without mentioning the First Lady of this chamber, Miss Dale Burns. Miss Dale Burns. Also, I'd like to recognize the President Pro Tem of the Senate, Mr. John Kennedy. And the Speaker Pro Tem, Ms. Jan Jones. I'd like to recognize, if they could all stand at once, our constitutional officers. Our constitutional officers, please rise and be recognized. Y'all stood at once, didn't you? How about our members of our judicial branch? How about they stand and be recognized as a judicial branch? At this time, it gives me great pleasure to introduce our great Georgian and longtime friend to this body, the Honorable Michael P. Boggs. Chief Justice Boggs was appointed to the Supreme Court in 2016 by Governor Nathan Deal. Previously, Justice Boggs served as elective office and judge of courts of appeal, as a Superior Court judge in Waycross Judicial Circuit, as well as being a member of this body for 4 years here in the legislative branch. Justice Boggs was raised in Waycross, Georgia, and obtained his undergraduate degree from Georgia Southern University. In 1990, he earned his Juris Doctorate degree from Mercer University, where he distinguished himself on the Mercer's moot court team. Following his graduation from law school, Chief Justice Boggs practiced law in Atlanta until returning home to Waycross, Georgia. In Waycross, he maintained a general civil trial practice while also serving as the county attorney and special assistant general. In 2000, he won the election as Georgia House of Representatives. 4 years later, he was elected Superior Court Judge of Waycross Judicial Circuit. Chief Justice Boggs served as a member of the Georgia Special Council on Criminal Justice Reform in 2011 and was co-chairman of the Georgia Criminal Justice Reform Council. He currently serves as a member of Governor Kemp's Georgia Behavioral Health Reform and Innovation Commission. He also serves as an appointee of Governor Kemp to the Georgia Judicial Nominating Commission. Chief Justice Boggs lives in Pierce County with his wife, Heather, a kindergarten teacher for many, many years in the local public school system. I will also add a personal note to Chief Boggs, is he presided over my baby sister's wedding about a month ago. So of all these accolades he has right now, we're going to find out how good of a preacher he was here in a few months. So, well, please join me in welcoming our Chief Justice of the Supreme Court, Justice Michael P. Boggs.
Thank you. Thank you. Thank you. Lieutenant Governor Jones, Speaker Burns, Madam First Lady of the House, Dale Burns, President Pro Tem Kennedy, Speaker Pro Tem Jones, members of the General Assembly, constitutional officers, Presiding Justice Peterson, my colleagues on the Georgia Supreme Court, Chief Judge Mercier, Vice Chief Brown, and judges of the Court of Appeals, other judges that are here with us today, and my fellow Georgians. I'm honored. Good morning, and thank you for the opportunity and invitation to be back before you all today to update you on the ongoing work and commitment of Georgia state courts to uphold the rule of law and serve the citizens of Georgia. I'd like to begin by acknowledging all of the hardworking folks who keep our state courts operating during these enormous challenges that we face. Please know that while Georgia's court system is one of the busiest and most efficient in the nation, our judicial system, and in particular our trial courts, do not operate in a vacuum. Efforts of our judges to improve the administration of justice and uphold the rule of law would be meaningless without all of our valuable judicial system partners. These include civil lawyers and prosecutors, defense attorneys, victims advocates, court administrators, court clerks, administrative assistants, court reporters, court interpreters, bailiffs, deputies, IT staff, and even our janitorial staff. Consider, if you will, that these professionals are all spokes on the wheels of justice. If any one of them is missing in any case, the wheels simply won't turn. Indeed, without each of them, our courts would not be able to function, and our courts would be unable, therefore, to meet their constitutional duties. They are truly the foundation of the judicial branch of government, and because many of these people largely work behind the scenes, they probably do not hear our thanks often enough. So, to all of these judicial system professionals who make our judicial system work, thank you on behalf of all of the judges of this state. Last year, I stood before you and told you that the state of Georgia's judiciary was strong. It was true then, and it is true now. But like other areas of government, Georgia's judiciary also faces significant challenges. I'd like to take the opportunity this morning to discuss the work of our courts and to highlight some of these challenges. I want to assure you, though, that despite challenges, our courts remain steadfast in applying and interpreting, not making, the laws and Constitution of our state. And, as always, I want to again express our appreciation for the trust and support that you all in the legislative branch have shown each of us as we seek your partnership in addressing a wide array of issues affecting our courts. I begin by expressing the gratitude of the entire judiciary for the financial assistance that Governor Brian Kemp granted our judicial system at the height of the COVID pandemic, at a time when trial courts quickly had to pivot, adapt, and innovate to meet the unique obstacles created by unprecedented times. In some courts, we're still feeling the aftershocks of backlogged cases, but our judges across the state are working hard and we are making progress. As a result of the ARPA, American Rescue Plan Act funding allocated by the governor's office to the judicial branch, you should know that every circuit that requested help was awarded some amount of relief, and many of them, multiple rounds of awards. To date, that's 46 of Georgia's 50 judicial circuits represented by nearly every legislator in this room. Grants to those circuits have allowed them to hire temporary personnel, update courtroom technology, rent larger venues, and procure additional resources to help them move their case backlogs. And a recent study objectively validates the use of these funds and demonstrates that the funds are indeed working. We're proud to report that the number of pending serious violent felony cases continues to decrease statewide, while overall jury trials have continued to increase. This progress has not been easy. In 2021, at the height of the pandemic, circuits reported an average increase of 24% in their pending serious violent felony cases. Some circuits reported even more than a 100% increase in those cases. Fortunately, managing cases has been greatly assisted by the ARPA grants. Since the initial awards were made, judicial circuits across Georgia are now reporting an average 11% decrease in pending serious violent felony caseloads. This is significant progress, particularly given the growth of our other ongoing and interwoven challenges affecting our judges' efforts to move dockets. I'd like to offer you just two examples of how our courts are using ARPA funds in moving cases. The Chattahoochee Judicial Circuit in Columbus made very creative use of its grant money to come to a temporary solution. They outfitted the Columbus Ice Rink and Columbus Civic Center as jury selection and trial venues. Also during that time, their then Chief Judge, Gil McBride, said that more than a dozen new employees, including 3 assistant DAs, 2 Superior Court clerks, part-time and full-time deputies, and 1 part-time and 4 full-time assistant magistrates, were added to the circuit to handle specialized court objectives. As a result, within the first 8 months of 2022, that circuit held more jury trials than in its pre-pandemic capacity. And speaking of Columbus, and on a personal note, all of Georgia's judges join in expressing our condolences on the passing of Chairman Richard Smith, a great friend and a great American. On another note, and as another example, in the Stone Mountain Judicial Circuit in DeKalb County, pending serious violent felony cases increased by 2,220 cases between 2019 and 2021. Since the implementation of its very first grant award, that circuit, though, has significantly reduced this felony caseload. They, too, have increased jury trials, holding 77 jury trials in 2022. Chief Judge Letitia Deere Jackson reports to the ARPA committee that her circuit effectively established a separate division within its Superior Court to handle backlog cases. They had weekly trials and pleas clearing the most serious of those cases. However, she also reports that the circuit continues to struggle with attracting certified court reporters and interpreters to return to courthouse proceedings after becoming comfortable with working from home for several months. Despite the enormous progress that courts are making in moving cases with the assistance of ARPA grants, our judicial system simply cannot fulfill its obligation to deliver justice without a full array of professionals beyond those available by the resources offered through the ARPA grants. Across our state, there are deficits in the numbers of court reporters, prosecutors, public defenders, court staff, and even sheriff's deputies. Just as it is critical to have enough doctors, nurses, and teachers to adequately deliver health care and education services to our citizens, so too must Georgia have enough law enforcement and public safety officers, lawyers, and court staff professionals to effectively and efficiently keep the wheels of justice turning. You will recall that during his State of the State address just last month, Governor Kemp noted workforce development challenges in state government as a really serious issue in Georgia. I truly appreciate the governor's focus on this critical issue, as these challenges also significantly affect the judicial branch. You will recall the governor saying that it is no secret that most state government jobs pay less than private sector opportunities in the same line of work. He went on to say that, but many of our employees do it because they feel a sense of public service. They want our state to succeed. This devotion to public service is certainly true with our state judicial branch employees, who are committed to the important work of the judicial branch. However, even within the Supreme Court, we have experienced significant staff turnover at a rate of over 57% since 2019. We're seeing experienced staff attorneys leaving for more lucrative positions in private practice or moving to other government entities. What's more, this is occurring at a time when approximately half of our court staff attorneys are set to retire over the next 5 to 10 years. The Court of Appeals is likewise not immune and has seen similar attrition, with 10 law clerks and administrative assistants leaving for better pay or retirement over the last 18 months. Of course, we don't blame them. Today's rate of pay is not as competitive as the state salaries offered by the courts in the 1980s and the 90s, and this compensation landscape adds yet another layer of difficulty to our efforts to attract and retain top-tier talent. We must reckon with the fact that this trend depletes our pool of seasoned legal professionals and necessitates time-consuming recruitment and training efforts for their replacements. Others have long recognized our state's appellate courts as among the busiest in the nation, taking in thousands of appeals and other matters and issuing hundreds of opinions each year, all within our constitutionally mandated deadline of 2 terms of court, the equivalent of about 6 to 8 months. For comparison, the U.S. Supreme Court issues only about 70 to 80 opinions a year, and I'm not aware of any other state's appellate courts that have this kind of deadline. So, filling staff vacancies in our courts is especially important to handling the workload, making sure we are performing at the highest caliber while also meeting our constitutional mandates. And the challenges related to pay parity are not limited to just law clerks and staff attorneys. It is also critical that the state compensate the state's judges sufficiently to attract good ones and keep them. A Judicial Council committee led by my colleague, Justice Charlie Bethel, and Superior Court Judge Rusty Smith from Toccoa recently completed a comprehensive compensation study regarding state-paid judges. And the recommendations of that committee, supported unanimously by the Judicial Council of Georgia, have been introduced for your consideration in House Bill 947, sponsored by Chairman Rob Leverett. We respectfully ask for your careful consideration and support of this initiative. And even beyond the challenges we have at the appellate courts to retain clerks and staff attorneys, notable other workforce challenges for the courts persist. The Prosecuting Attorneys Council of Georgia, which is tasked with training and supporting the hundreds of elected and appointed prosecutors across our state, reports that as of the start of this year, there are a total of 41 assistant DA position vacancies statewide. 8 judicial circuits out of our 50 have assistant DA vacancy rates of 25% or higher. You wouldn't be surprised to find that many of these are in our rural areas of the state. And you don't have to be a lawyer to know that judges alone cannot move criminal cases without prosecutors. Unfortunately, our trial courts' workforce challenges aren't limited to just a deficit of prosecutors. As I previously mentioned, many other judicial system professionals play important and necessary roles in trial court proceedings. Among them are court reporters. While the overall number of certified court reporters in Georgia seems to have gone up in recent years, that apparent growth lags far behind the ever-growing demand our state courts have for those legally necessary to take down every word in a court proceeding to preserve the record. In some circuits across this state, circuits are resorting to the issuance of emergency judicial permits to allow non-certified court reporters to temporarily stand in for a limited period of up to 1 year when no other certified court reporters are available. Adding to that situation, the average age of court reporters before the pandemic was 54 years old, with a full 70% of certified court reporters being over the age of 50. Today, frankly, many of them are facing retirement if they have not already decided to retire. Making matters more dire, fewer new reporters are going through the process to become licensed. This means there won't be new ranks to replace the outgoing ones. And without enough court reporters to meet the demand, trials and other proceedings will slow once again. Let me paint you a picture as a judge of what that actually means. Imagine, if you will, a courtroom ready to try a serious violent felony case. The judge is on the bench, judicial staff is present, the bailiffs are there, the defendant has been brought from jail, sheriff's deputies are providing security, an interpreter is present. Victims and victims' advocates are present. Witnesses have been subpoenaed, and jurors have been subpoenaed and have taken time off from work and are present. But there's no court reporter ready to transcribe the proceedings. So, despite the seemingly full array of judicial resources, nothing can be done without the court reporter. Indeed, one of the spokes on the wheels of justice. And because court records are also a vital component of appeals, a deficit of court reporters can also slow matters after trial from reaching finality in my court and in the Court of Appeals. These delays not only affect the party litigants, but in criminal cases, the delay also affects closure for victims of justice. And we would all agree, I hope, that justice delayed for anyone is justice denied. And to be sure, our state court judges alone have little means to manage these particular challenges, although we are exploring potential options and we hope to have some solutions for you all to consider next year. On another front of judiciary-related challenges, a recent report by the Georgia Sheriff's Association shows that there are over 1,000 unfilled full-time and part-time sheriff deputy positions statewide. While the judiciary does not have oversight of public safety and law enforcement personnel, this number does affect us deeply because deputies play a very critical role in our judicial system, not least is keeping our courthouses and courtrooms safe. What's more, on top of the security they provide, many law enforcement officers are also called upon to be witnesses in criminal proceedings. Without their vital work, it is much harder to prosecute and move cases, and our courtrooms are much less safe. In sum, all of these interrelated judicial branch challenges affect the resolution of court cases. I'd like to now turn your attention to an issue that no judge in any society ought to have to address, and that is the issue of growing threats to judges. Over the last few years, there have been several alarming attacks on judges in the U.S. that have made national news. Least you were unaware, in June of 2022, retired Wisconsin Circuit Court Judge John Romer was murdered in his home by a defendant he had sentenced to prison. In October of 2023, Maryland Circuit Court Judge Andrew Wilkinson was murdered outside his home by a litigant involved in a child custody dispute. In December, just a few months ago, a man was arrested in Nevada and charged with solicitation to murder 2 state court judges. And just a month later, a county district court judge in Nevada was tackled while on the bench by a defendant after she denied him probation. No doubt these attacks and threats are meant to intimidate and influence courts away from serving as fair and impartial arbiters of justice. Georgia judges will not be threatened or intimidated into abandoning their constitutional duties. But incidents like these are repugnant to the rule of law, and if left unchecked, they threaten the very independence of our judiciary. These attacks prompted the Conference of Chief Justices, on which I serve, and the Conference of State Court Administrators to write a letter calling on the federal government and federal lawmakers to bolster judicial safety. In that letter, they state that for our legal system to function properly, judges must be able to administer justice free from threats and violence. They need to know that court staff and family members are safe. The public needs to know that the people overseeing their cases do so professionally and objectively, unhindered by intimidation and free from reprisal. In short, for the rule of law to mean anything, the very bedrock of our society, judges, court staff, and their families and the public must be protected. On behalf of our state court judges and their staffs, I greatly appreciate your attention to this issue in Georgia. A little over a year ago, the Supreme Court created the Judicial Council Standing Committee on Judicial Security, which is led by my colleague, Justice Sean Ellen LaGrua, and Judge Brian Rickman from the Court of Appeals. And I greatly appreciate their work. In addition to the judges serving on this committee, we have many vital law enforcement leaders serving in advisory capacities, including Richard Hyde, John Heinen, Chris Wigington, and Stan Cooper. These leaders are monitoring judicial safety issues in Georgia and are actively working to identify steps to protect the safety and security of Georgia's judiciary. Importantly, the Security Committee's work and recommendations hold promise for improvements, both for judges and for you. We know that y'all are dealing with similar challenges, which have become all too real for too many of you in recent weeks. So while some of our security measures are specific to the judicial branch, many are more broadly applicable. This includes, for example, proposed legislation to require state and local governments to keep confidential the personal identifying information of judges, a proposal already passed or in the works in 31 other states, and a protection that could easily be expanded to cover other elected officials. The committee work also includes training that Director Chris Wigington and his staff at the Georgia Public Safety Training Center have developed along with representatives from all classes of courts. Later this spring, they will present that training and will also make available this training to any member of the legislature who would like to attend. We all hope that you will find these recommendations responsible and responsive to a growing threat. Changing gears a bit, I'd like to reiterate my concern that our courts continue to experience significant challenges when it comes to civil cases. Although, as you know, indigent criminal defendants receive publicly funded legal representation, low-income civil litigants are often on their own. Instead, where civil litigants can't afford a lawyer, the burden of representation falls to the litigant to represent themselves, or rely on a far too small and under-resourced patchwork of volunteers or organizations who take cases for little or no fee. The Georgia Legal Services Program, which arose in the 60s to address the dearth of lawyers in rural areas where legal help was less available, is fortunately still going strong today. But even these services face challenges, as that program currently has more than a dozen openings in places you know, places like Albany and Valdosta and Columbus and Dalton, Macon and Savannah, and even in their Piedmont Regional Office. And while there are numerous attorneys in and around Atlanta willing to step up, there's still a need for locally based lawyers in these further outlying cities and towns. Without them, it's more difficult to provide civil legal services to survivors of domestic violence, those in desperate need of housing, and other law-abiding people with critical legal needs. I bring to your attention that both the Judicial Council amended fiscal year 24 and fiscal year 25 budget request contains several proposals to help address this problem. And while we have more than 34,000 active licensed attorneys in the Peach State, please recognize that the severe deficit of lawyers we have, especially outside of the Atlanta metro area. Many of us, myself included, often chuckle at the occasional lawyer joke. But when you really need a lawyer, not having one can be deadly serious. The ugly truth is that many people in Georgia simply do not have access to a lawyer at their most critical time in their lives, either because of where they live or because they can't afford one. Last year, during my first State of the Judiciary address, I told you all that there were 7 counties in Georgia with no licensed lawyers. 0, none. Sadly, that number has not changed and remains the same. Of course, Georgia alone is not alone in wrestling with the problem of legal deserts. Data from the American Bar Association reveals that in the year 2020, 1,300 counties in the United States had fewer than one lawyer per 1,000 residents. Many had no lawyers at all. And we know that the lack of legal advocacy can make it harder for folks to access other needs, such as housing, medical care, and child support. Meeting this challenge in Georgia will not be easy. On the one hand, we still have a relatively steady stream of prospective attorneys seeking admission to the bar. 732 new lawyers passed the July 23 bar exam. But it is highly likely that most of them plan to practice in and around the Atlanta metro area, where the private sector jobs tend to pay higher salaries. Pay is also a compelling consideration for new lawyers who are facing sizable student debts. Whatever the causes, there is much work to be done to recruit lawyers who can meet the basic needs of those dealing with adoptions or child custody matters, business disputes, evictions, contested wills and estates, and more in our currently underserved parts of the state. One way the Supreme Court is addressing the lack of lawyers in rural areas is by removing unnecessary barriers to practicing law in our state. I'm proud to announce that last fall, my colleagues and I on the Supreme Court voted to revise the rules governing provisional admission to the practice of law, which included for the first time a provision and a process for spouses of active duty service members. This change was part of our ongoing review of the recommendations of the Georgia Lawyer Competency Task Force. And under these new rules that went into effect on January 1st of this year, the lawyer spouse of an active duty service member who is currently assigned to a post in Georgia may obtain a provisional license to practice law here in Georgia under certain conditions without having to sit for the bar exam. This new provisional admission will offer them greater certainty. It'll save them considerable time and cost also as they continue their legal careers. It also recognizes, I think, the significant sacrifice the spouse is making to serve our country. A sacrifice made all too real this past week as 3 Georgians lost their lives and many others were wounded while serving our country in Jordan. Let me now turn briefly to some other emerging challenges facing the judiciary. New advancements in generative AI present new opportunities and risks for Georgia courts. Our Judicial Council Standing Committee on Technology is studying the issue, and I'm one of 3 state Chief Justices currently serving on the National Conference of Chief Justices AI Rapid Response Team, a team created to examine some of the immediate issues related to the use of generative AI in courts and the impact it could have on court proceedings and the integrity of the judicial process. You are all undoubtedly aware of the increasing challenges generative AI is causing across society, and the courts are not immune. Just like any tool, AI can be implemented in ways that enhance and indeed improve the administration of justice and even improve access to justice. But it can also be used unethically to threaten the veracity and integrity of court proceedings. So while our court is not quite ready to make any sweeping rules changes, we are keeping an eye on this emerging technology and are prepared to ensure that the operations of the court are not adversely affected. Another critical issue facing our trial courts relates to case management and case data. The value of having access to reliable, accurate judicial data is paramount to informing judicial decision-making and improving public safety. Just this past week, we've seen the Atlanta Judicial Circuit dealing with enormous challenges due to the hack of their IT system, which included their judicial case management system, which highlighted the need for information security as well. We assure you that we will continue to explore new ways to address this issue to improve judicial case management in Georgia. I'd like to end by saying what a privilege it is to be a judge. And while I often like to remind lawyers that dedicated professional counselors are necessary to an independent judiciary, so too are judges. And an independent judiciary, grounded in faithful adherence to the rule of law, is critical to upholding our country's foundational principles of freedom and democracy. And adherence to these principles necessarily helps build public confidence in our courts, not as partisan weapons or super legislatures, but rather as judicial officers who have taken an oath to administer justice without respect to person, to do equal rights to the poor and the rich, and to faithfully and impartially discharge and perform all of the duties incumbent on us as judges of the courts of this state according to the best of our ability and understanding and agreeably to the laws, the Constitution of this state, and the Constitution of the United States, so help us God. My good friend and former colleague, retired Justice Robert Benham, has said many wise and notable things in the decades he served our court and our state. But one that sticks out most in this moment is his belief that throughout history there have been 3 great professions: medicine, because it preserves the body; theology, because it preserves the spirit; and the law, because it preserves civilization. I concur. Thank you all for inviting me here once again to speak on behalf of Georgia's judicial branch. I continue to be optimistic about what is ahead while also remaining realistic about the challenges we are facing. May God bless you all and your families, and may God bless the great state of Georgia and the United States.
Good job, wonderful job, and thank you for your service, Justice Boggs, and thank you, Supreme Court and Justice of Appeal. Thank you for your service. We so appreciate that. Mr. Doorkeeper, please escort Chief Justice and the Justice of the Supreme Court, as well as the Justices of the Court of Appeals. Please escort them out of the chamber at this time. Thank you. Appreciate it. Thank you. Let's give them a round of applause.